Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Labenz. Today we are going to talk about discovery. We're going to talk about discovery in the context of a child custody establishment case. And discovery is a more advanced tool. Generally, self-represented parties don't get too involved in discovery, but with today's lesson, hopefully if you feel the need to engage in discovery, you'll have the information resources you need to do so. Also, if you receive a discovery request from the other side, let's say your co-parent is represented by an attorney and they serve you with a discovery request, you'll have information in this video to know how to approach that request and how to respond and what's expected of you. So this video will apply whether you're looking to what we call propound, to send out a discovery request, or if you receive one, if you're served with a discovery request. Okay, let me get to the next slide here. Here we go. So what is discovery? Discovery are tools that you can use, so legal tools, to obtain answers, information, and documents relevant to your case. Let's look at disclosure versus discovery. So disclosure are documents and information relevant to your case that you are required by law to share with the opposing party. So that's under Rule 49. We did a separate video on disclosure requirements. And so that's disclosure. That's Rule 49. That's what both sides are required to exchange with each other. And then there's discovery. Discovery are these legal tools that are available to both parties to use to obtain answers, information, and documents relevant to your case. So discovery is optional. It's not required as far as sending it out. Responding to it is required unless there's a defense that's valid. But discovery doesn't arise in every single case, whereas disclosure is always required. So, and generally you can get sufficient information through disclosure. And discovery is if the stuff that you get in disclosure isn't enough, or, you need more, you want a longer history for some reason, or there's specific information that you're looking for to prove a certain part of your case that wasn't a required piece of disclosure. Let's look at examples of these discovery tools. There's a subpoena, interrogatories. Interrogatories can be uniform interrogatories or non-uniform. Uniform interrogatories are these set standard lists of questions for family law that you can utilize, whereas non-uniform are questions that you can just make up. They're non-uniform. They're ones that you make up, whereas the uniform ones are the standard ones. There's a request for production, a request for admissions, a deposition, evaluations. Okay, let me go back to this last slide. Okay, so a subpoena. This is where you go to court, you go to the clerk's office, and you have your subpoena form filled out and you give it to the clerk, you pay the subpoena fee, and then they put their court stamp and the clerk signs it, and it's now an official order of the court. And then you serve that on whoever you're looking to either get documents from or have testify. So there's two types of subpoenas: a subpoena that orders a person to appear in court to testify, or what we call a subpoena ducis tecum, because we always have to have the confusing legal words, a subpoena ducis tecum, which is for documents. So you could serve a subpoena on a bank, for example, to get bank records. And we will go through a subpoena form and we'll talk more about subpoenas. Interrogatories, those are the questions that you are serving on another party and asking them to answer. They can be uniform or non-uniform. A request for production. This is where you are asking a party to produce certain records. And I'll show you an example of a request for production template. A request for admissions. This is where you're asking yes or no questions. You know, you are seeking sole legal decision making, yes or no, if you were looking to nail down someone's position. However, that should be clear from their pleadings, but just an example of something you could ask in a request for admissions. You're seeking a yes or no answer. A deposition is actual testimony. It just doesn't take place in court in front of the judge. Instead, it's usually in an office. There's a court reporter there. You are put under oath and you give sworn testimony about whatever you're questioned about. So that's a deposition. And then evaluations, a mental evaluation, a vocational evaluation that can come up in a spousal maintenance claim. Of course, that wouldn't be in a child custody case. So as far as custody, more, evaluations could more be, custody evaluations. There could be a mental evaluation of a parent, psychological evaluation, I should say. So we'll talk more about value or evaluations as well and how to request one. All right, first let's start with subpoenas. A subpoena is a court order to produce documents or to appear in court to testify. You can subpoena records from an institution or a corporation. You can subpoena a witness to testify at an evidentiary hearing or at a trial. Here's some examples of records that can be obtained via a subpoena. This is not at all an exhaustive list. This is just a few examples. You can subpoena bank records from a bank. You can subpoena credit card records from the credit card company. You could subpoena investment or brokerage account records from the institution that manages the account records. So, from Fidelity, for example. Counseling records. Now, as a parent, you should be entitled to get counseling records related to your children. And of course, you would be entitled to your own counseling records, but you could subpoena your co-parents' counseling records, for example. So we're going to go over the form, the standard Maricopa County form for subpoenaing records, and I want to give you a few tips on filling out the subpoena form. First of all, you may need to do some research to figure out who to name in the subpoena. Now, if you are, and we're talking about a subpoena for records. Obviously, if you're doing a subpoena to get somebody to appear in court to testify, you're going to know the name of the person you want to testify. So here we're talking about records. And if you're wanting records, for example, from a bank or from a counselor's office, who are you sending this to? What's the name of the bank? Who's the appropriate person? What's the department? You want to get some specifics, most likely by contacting the institution or the company or the bank where you're seeking to get records and get some information. Now, for some of these companies, you can find this information on their website. Other companies, you can call them. Some of this information could be in their corporate records for the state they're incorporated in. So the bottom line, though, is that you need to figure out where you're sending this subpoena, the appropriate person, the department, as well as the correct address. So some really big corporations, like credit card companies, they will have a specific subpoena department and have a specific address that's different from their main mailing address for subpoenas. So this is where I'm saying you need to do some research to get the proper information to fill out the subpoena so it's going to the right person, the right department, and things can get processed in a timely manner. Otherwise, you can experience delays or just have your subpoena be ignored because it's not going to the right place. In your subpoena, use very clear and precise language describing the records you're requesting be produced. If you are looking to subpoena counseling records and you just say, I want counseling records, it's like, well, of who? Whose counseling records? What time frame? You need to give the scope of the records along with sufficient information so that the person who's tasked with producing the records knows what you're requesting and can produce the records you're requesting. So the time frame is very important, and the whose records they are, any identifying information. If you have a social security number for that person, if you have their date of birth, especially with some of these bigger institutions, if you think about the type of account information they maintain for the person, or particular account numbers, putting in as much specific information about the exact records you're requesting can make sure or can ensure that your subpoena is actually fulfilled and you get what you're looking for. Also, you want to clearly state the deadline for them to produce the records. By law, you need to give at least 14 days. And also you want to specify, how do you want these records produced? I prefer email because generally when I'm getting records via subpoena, I'm getting a lot of records, hundreds of pages, and I don't want hundreds of pages of hard papers. I want that to be electronic because then it's a lot easier for me to use and maintain and put in part of my system. But you may not want electronic records. Maybe you want hard copies. So specify how you want the records produced and where do you want them sent to. Provide your email address, provide your mailing address, make it very clear when they need to comply and how they can comply with your request. Now, if you give a brief deadline, if you only give 14 days, you're most likely to receive a request for an extension from the other side saying, I can't comply that fast, especially if it's a big bank or corporation, or even, some counseling offices, that just may be too short of amount of time. So keep that in mind that, you likely can get a better result if you work with them instead of making demands and trying to get them to work with you faster than they want to. This also means that you want to issue a subpoena early on in your case. You're not going to want to do this 30 days before trial. You're just not going to get the information and records you need in time for your trial. So this should all be done earlier on in your case so that you have sufficient time to get the information and to disclose it to the other side. Okay, so we'll get to these questions at the end. Okay, and I had one more here. Keep in mind that the person or business producing the records can charge a fee to produce the records. So sometimes they do by page, sometimes they do it by the amount of time they spend, complying with the subpoena. Generally, the expense isn't that much, $100 or less, but just be aware of that. And if you're going to request a lot of records and things like that, be aware that the more you request, the more you may need to pay to fulfill the request. Also, if you're requesting hard copies, they could charge you for that. So keep that in mind too. All right, here's the Maricopa County standard form for a subpoena for a family law case. So you need to fill out your caption, and then this is where I was saying you need to get accurate information for the name, address of who you're sending the subpoena to. And then what type of subpoena is this? Is this for attendance at a hearing or trial? If so, this is where you're going to command somebody to appear and include all the information about the hearing they need to appear at. Or if it's for taking a deposition, you're commanding them to appear at a deposition. That would be number 2. And then here's the subpoena duces tecum. This is for records. Okay, so if you're looking for records to be produced, check here and list out. This is where you want to be specific about what you're requesting. If you can't fit it all there, you can attach an additional page. And then when do they need to produce it, where and how? This is where you can modify this to say, send it to me via email. Here's my email address. And so this is, and then when you file this with the court, this is where the clerk will fill this out, the date, and the clerk will sign and stamp this and make this an official court order. Here's a standard form. This needs to go along with the subpoena, telling the person who receives the subpoena what their rights are. More information about that, how to object to the subpoena, what are proper grounds for objecting, how the court can modify or void a subpoena. And then this is a final signature by the clerk. Now you'll see there's this certificate of service. When you send out a subpoena, you should send a copy to the other side, to your opposing party. And then you need to serve the subpoena itself. So under Rule 52D of the Arizona Rules of Family Law Procedure, a subpoena may be served by any person who is not a party and is at least 18 years old. Serving a subpoena requires delivering a copy to the named person, and if the subpoena requires that person's attendance, tendering to that person the fees for 1 day's attendance and the mileage allowed by law. So if you are requesting somebody to come to court to testify, you need to pay them for 1 day's attendance and the mileage. So another thing to keep in mind. Now, some witnesses won't demand that you pay that. If they're, maybe you just need to give them the subpoena so they can show their work to get out of work to come. But others who need to get out of work to come may want to be compensated for that. So keep that in mind. Now, although this allows for hand delivery of the subpoena by anybody who is not a party and who's at least 18 years old, this may not be possible, for example, if you're serving a corporation to get records. So this is really, if you know the person, you can go to their office or they're there to testify, and you can have somebody who's not a party and is at least 18 years old deliver it. But that's not going to work out for every type of subpoena. Remember that a copy of every subpoena must be served on every other party in accordance with Rule 43, which at this point in your case would be sending a copy by mail or by email if they've agreed to service by email. A subpoena may be served anywhere within the state. As far as this hand delivery deal, it can also go out of state, but if you're going out of state, the institution needs to work with you. They could object based on it being an out-of-state subpoena, and then you'd have to domesticate it in the state they're in and then serve it, which is a whole lot of hoops and legal stuff to go through. But I will let you know, in my experience, if I'm dealing with like a credit card company or a bank, even if they're not in Arizona, I serve them a court subpoena, they comply with it. They don't make me jump through a bunch of hoops. So, all right. So with that said, upon service of the subpoena, you file the proof of service with the court. So let's look at this. Oh, sorry, those are out of order. Number one, you'll submit a completed subpoena form to the clerk. So these are your steps for service of process for the whole subpoena process. So fill out your subpoena form, take it to the clerk, pay the fee, and then serve the subpoena and file proof of service of the subpoena with the court. Let's look at additional service options other than the hand delivery. There's acceptance of service. You could mail this to the other side, you could meet with them, but they sign it before a notary, and then you file the proof, or you file the acceptance of service with the court. You can do certified mail restricted delivery, and then you can file the signed green card with the court with the affidavit of service. Or you can hire a process server to serve the subpoena. So obviously the subpoena can be a little difficult. There's obviously a lot of steps to follow. You need to be clear, but at the same time, if you're dealing with certain institutions that handle subpoenas on a regular basis, this could be pretty straightforward. Here's the affidavit of service of subpoena form for Maricopa County. So this is indicating how the subpoena was served. It's under penalty of perjury, and then you could file this. Of course, this form is really going to work if you have someone doing the hand delivery of the subpoena, and that isn't always going to work in every single case. So in that event, we've got these other options of acceptance of service, certified mail, or a process server. So here's that acceptance of service by certified mail form. And you'll see there isn't an option for the subpoena in the boxes, but you can list below here, subpoena, you can fill that out here. And then this paragraph applies, but this response deadline, the default judgment, the 2, 3, and 4, these don't apply for subpoena. So you'll have to modify this form, and just keep that in mind that when we're dealing with these standard court forms, sometimes you do need to modify them to make them work for your case. These are standard forms for everybody. And so sometimes you do need to make some modifications. Here's the signature showing the acceptance of service, and then this would get filed with the court. If you're going to do service by certified mail, here's the standard Maricopa County form for that, where you'd fill out your information. Again, the subpoena is not in the boxes, but you can list here that it was a subpoena, list out exactly what was served. And then you'll sign here. And this is where you attach the signed green card and a copy of your mailing receipt. Okay. Now we're going to move on to another type of discovery requests, which are called interrogatories. So interrogatories can be uniform, which are the standard ones, and I'm going to show you the standard ones, at least for child custody. And then the non-uniform interrogatories, which you can just create on your own. This is under Rule 60 of the Arizona Rules of Family Law Procedure. Interrogatories are written questions served by a party on another party and answered in writing and under oath. In connection with any petition, unless the parties agree or the court orders otherwise, a party may serve interrogatories. 40 is your limit, okay? And a uniform interrogatory and its subparts count as one. Any subpart to a non-uniform interrogatory is a separate interrogatory. So 40 total between uniform and non-uniform. And then there is this set form that you can find in Rule 97 of the Arizona Rules of Family Law Procedure, Form 7, which has all of the uniform interrogatories. I've picked out the ones that apply to custody, and I'll show you those in the coming slides. For serving non-uniform interrogatories, you serve a copy on every party who's appeared in the action. For uniform interrogatories, you serve a notice of service of uniform interrogatories containing the names of the party and the attorney to whom the requests are made, and each uniform interrogatory for which the propounding party requests an answer. The propounding party must also serve the notice on every other party. Now, yes, the rule says you're supposed to do this notice of service. The regular uniform interrogatories are very long. A lot of them apply to divorce matters. So you can take the full standard document, serve that, and then on top of it, do this notice of service, and in there indicate the exact numbers you want the other side to answer. That's one way to do it. I've done it another way, which I believe fits the spirit of this rule and would not garner an objection that's worthwhile, which is I just tailored down the uniform interrogatories to the ones that apply to children, and I have all those there. Now, in the materials below, that document is in Word format, so you could tailor it further. In other words, eliminate any questions that you don't want to ask. Alternatively, you could do this notice of service and name the numbers of the questions that you want the other side to ask. But the general gist of what I'm saying is you should not blanket serve these uniform interrogatories without narrowing it down. Because if you do, or if you fail to narrow it down, the other side can just go, objection, you didn't narrow it down. I'm not answering all of these. They don't all apply. So if you don't want to go through that delay, then you need to narrow down and just identify which questions you want the other side to answer, because not all of them are going to apply in your case. None of the interrogatories are filed with the court. So when one party serves them on the other side, they don't file it with the court. And when you respond, you don't file it with the court. It's just exchanged between the parties. Okay, time to respond. Unless the parties agree or the court orders otherwise, the responding party must serve its answers and any objections within 40 days after being served with the interrogatories. If, however, you were served with the interrogatories when you were served with the petition for establishment, then you have 60 days. So if the interrogatories come in with the original court filing that you're served with, so when you're served with the petition, then you have 60 days. But if you've already responded, the case is, open and going, then it's 40 days from service. Now, keep in mind, there's also 5 days for mailing. So it's actually 45 days and 65 days because you get an additional 5 days for mailing. Now, with this, actually 60 days, you probably don't get the extra 5 because you would have been served. So that'll be 60. The 40, though, is 45 days. All of your answers to interrogatories are under oath. So you need to answer as if you were on the stand testifying. You can object. Grounds for objecting to an interrogatory must be stated with specificity. Any ground not stated in a timely objection is waived unless the court for good cause excuses the failure. If a party states an objection, it must still answer the interrogatory to the extent that it is not objectionable. A party who answers the interrogatories must sign them under oath. And an attorney who objects to any interrogatories must sign the objections. The answering party must serve the original answers with any objections on the propounding party and must serve a copy on every other party who has appeared in the action. The answering party must not file interrogatory answers with the court. So this is going to apply for every type of discovery request. Just like we went through with the subpoena. When you get the subpoena from the court, you need to serve a copy on the other side. When the documents come in from whoever you requested to produce the documents, you need to share a copy of those documents with the other side. Interrogatories, you serve it on the other side. When you answer, you serve it on the other side. And the actual responses are not filed with the court. Okay, an answer to an interrogatory may be used to the extent allowed by the Arizona Rules of Evidence. So because responses to interrogatories are made under oath, you can use the document in court at trial if you needed to. If the answer to an interrogatory may be determined by examining, auditing, compiling, abstracting, or summarizing a party's business, medical, mental health, behavioral health, employment, income tax, or education records. And if the burden of determining the answer will be substantially the same for either party, the responding party may answer by specifying the records that must be reviewed in sufficient detail to enable the questioning party to locate and identify them, and giving the questioning party a reasonable opportunity to examine and audit the records and to make copies, compilations, abstractions, or summaries. Okay, so this option to produce records, this isn't going to come up very often, but if there's very voluminous records and you're being asked a question that requires you to summarize them and you don't think you should have to, then you can tell the other side to do it and just tell them where to find the information. That's what this subsection D is saying. All right, let's look at some of the uniform interrogatories that apply to custody cases. So here's the cover page. You'd fill this out. Everything in this red color is what you will need to fill in for your particular case. Here's the instructions and definitions and instructions. Okay, uniform interrogatories, name and contact information. Now, if you know all of this information about your co-parent, you could take out number 1. Education and training. If one side is seeking legal fees and there's a question about Financial resources, education and training may be relevant. Otherwise, it might not be relevant at all to your case. Maybe child support, it could come up if you're saying that they should be attributed income because they have the proper education and background. So again, if these types of issues are arising in your case, number 2 may be a good question to leave in here. But if they're not at issue in your case, you could take that out. Employment. If there's a question for child support purposes about employment and income, here's all sorts of uniform interrogatories about employment. Now, remember, you can do 40 interrogatories, and for the uniform interrogatories, each subpart is 1. So even though this number 3 has A through F, this all is still 1 interrogatory. Health insurance. If this is at issue in your case, and obviously some of this, conversion benefits available to spouse, this can all be crossed out. But health insurance, as far as cost to insure your children, so you could cross out stuff related to spouse. Other income, if that's a question you have, you think that there may be hiding income. Employment benefits, if they're getting employment benefits that you believe should be counted as income in the child support calculator, number 8 could be a good interrogatory. Legal decision-making and parenting time. So all of these different questions about parenting time, decisions, see if there's anything you want or that's at issue in your case, you could ask this question. Child protective services, if you have questions about that. Personal limitations, any mental or physical limitations that would affect your ability to work. That could come up in child support. It can also come up in the best interest of the child standards because there is that factor, I want to say it's factor 5, that asks about any mental or physical issues that any parties in the case have. So that could come up there. Driving history. If there's an issue about the child being safe while driving with a co-parent or the co-parent having a bad driving record and raising safety concerns, here's some questions for that. Employment history. Have you ever been the subject of disciplinary complaints? If you think that that could produce relevant information in your case, there's that question. Criminal history. Have you or has any person residing in your household ever been investigated or arrested for any criminal behavior? So if that's an issue in your case, there's questions about that. Domestic violence, tax returns, attorney's fees and costs, witnesses and exhibits, expert witnesses, regular witnesses, and then affidavits and inventory. So this is for attorney's fees. Also, some of this is related to child support, but essentially the affidavit of financial information. And then if you're trying to make an argument that they have money to pay attorney's fees because look at all the stuff they have, then you could do a list of the personal property, ask them to produce a list of personal property, but that might not be an issue in your case. So again, you need to tailor this document to your case. You'd write in the opposing party's name here, tailor this document, and then they would sign here once they've answered everything. Serving the interrogatory. So service you can serve by mail. You generally serve the original and 1 copy of the interrogatories on the opposing party or their counsel. And then as long as these documents weren't served as part of the petition, then you have 45 days to answer. If it was part of the petition, then you have 60 days. Let's look at our next type of discovery request. This is a request for production of documents and things. So in the interrogatories, we were looking at producing answers to questions. And in the subpoena, we're either commanding somebody to appear in court to testify, or we're commanding somebody to produce records. That's not a party to the case. And here in a request for production of documents and things, We're asking the other party to produce documents or other things, not just answers to questions, but records. So this is under Rule 62. A party may serve on any other party a request within the scope of Rule 51B. 2, permit the requesting party or its representative to inspect, copy, test, or sample the following items in the responding party's possession, custody, or control. So documents, tangible things, or permit entry onto land or property to inspect it. So some of this inspection of tangible things and going onto property, that's going to be more relevant to a divorce case, but asking the other side to produce documents within their possession, that is within the realm of custody and things that could come up. So maybe you're wanting them to produce, you don't want to go directly to the counselor's office. You want them to produce their counseling records. You could ask that through a request for production. Okay. So let's look at the procedure. There's a limit of 10 on the request for production. So no more than 10 items or distinct categories of items. And then the request must describe with reasonable particularity each item or distinct category of items to be inspected, must specify a reasonable time, place, and manner for the inspection, and may specify the form or forms in which electronically stored information is to be produced. So same time frame as with the interrogatories, 40 days plus 5 days for mailing, or if you receive the request for production with the petition, then 60 days. For each item or distinct category of items, the response must either state that inspection and related activities will be permitted as requested, or state the grounds for objecting with specificity, including the reasons. An objection must state whether any responsive materials are being withheld based on that objection. And you also need to explain if you could produce part of the document, like redact part, and if that would satisfy your objection. Unless the parties agree or the court orders otherwise, these procedures applying to producing documents or electronically stored information. A party must produce documents as they are kept in the usual course of business, or must organize and label them to correspond to the categories in the request. A party must produce electronically stored information in the form requested by the receiving party. If the responding party objects to a requested form, or if no form was specified in the request, the producing party may produce the electronically stored information in native form or in another reasonably usable form that will enable the receiving party to have the same ability to access, search, and display the information as the producing party. And absent good cause, a party need not produce the same electronically stored information in more than one form. So just like we talked about with the subpoena, if you're asking that documents be produced, you need to indicate how you want them to be produced. Are you wanting hard copies? Are you wanting electronic copies? Are you wanting them emailed to you? Are you wanting them mailed to you? Are you wanting to come to an office to inspect them? Are you wanting to go to a home to inspect them? Let's say, anyways, the example I just thought of was better for divorce than custody, so I'm not going to go into that. But the bottom line is, with all discovery requests, you really need to be clear about what you're requesting and how you expect it to be produced. Here is a sample template for a request for production of documents and things. Okay. So fill this out, the name of each party, your case number, your county, who is this to, who's the other party that you're sending this to, and then are you the petitioner or the respondent? You're requesting what's the name of the opposing party to produce things in the attached list. And then this is where you can indicate, how do you want it produced? Email, mail, hard copies, email. So indicate all that here. Here's some more information about it. Indicate your date of mailing, the address you're mailing it to, and then you'd sign there. So here's some examples of things that could be requested under a request for production. Now, this is income related, so this could be used for child support purposes. But here we're looking at employment contracts, pay stubs, all records indicating any and all income received for the last 3 years, tax returns for the last 3 years, any and all personal expenses paid for you on your behalf by your employer or business. So again, tailor this to the exact information you're looking for. But if you're wanting a bigger picture, going out 3 years for income information, this would be one way to potentially get that type of information directly from the other side. All right, how do you serve a request for production? By mail. So you're going to mail the original and 1 copy of the request for production to the opposing party or their attorney. And then the response is due 45 days after the mailing. If this was after service of the petition, if you receive the request for production with the service of the petition, then you have 60 days. All right, now let's look at a request for admissions. This is under Rule 64. This is a written request to admit the truth of any matters relating to facts, law, opinions, genuineness of documents. Each request for admission must be separately stated. You get up to 25 requests, and it's the same time frame, 40 days plus 5 days for mailing, or the 60 days if the request for admissions is served with the petition. If a request is not admitted, the response must specifically deny it or state in detail why the responding party cannot truthfully admit or deny it. A denial must fairly respond to the substance of the request. So when you are answering a request for admissions, you want to be very specific in specifically admitting or denying the truth of any request for admissions. A party must state the grounds for an objection. You cannot object solely on the ground that the request presents a genuine issue for trial. The requesting party may move to determine the sufficiency of a response or objection. So if they don't think it's clear enough, they could get the court involved. And then a matter admitted under this rule is conclusively established unless the court permits the admission to be withdrawn or amended. The court may permit withdrawal or amendment if it would promote the presentation of the merits of the action, and if the court is not persuaded that it would prejudice the requesting party in maintaining or defending the action on the merits. An admission under this rule is not an admission for any other purpose and cannot be used against the party in any other proceeding. So these requests for admissions can have a lot of importance to them, because if, for example, there's a request, you agree that we should share joint legal decision-making, and you say yes, then that's deemed your testimony under oath. You've admitted that you want joint decision-making, and you can't change it unless the court allows you to withdraw it under this subsection B. So I don't have an example of a request for admissions here because I think it's a bit advanced for purposes of what we're doing today. But I did want to give you this information so you're aware of what a request for admissions is and that it is testimony under oath. So service, you'd mail a copy, the original 1 copy to the opposing party or their counsel, and then it's the same response time, 45 days, unless this was served on you with the petition, then you get 60 days. All right, depositions. So depositions start with a notice of deposition. The party who wants to depose a person must serve written notice to every other party at least 10 days before the date of the deposition. The notice must state the date, time, and place of the deposition, and if known, the deponent's name and address. How can a deposition be recorded? This is testimony under oath, must be recorded by a certified court reporter, and in addition may be recorded by audio or audio-visual means. So you could have a handheld recorder, you could do it via Zoom and record it, or a court reporter, but the bottom line is it does need to be recorded. And then the recording gets transcribed, and the party who originally noticed the deposition is responsible for the cost of the original transcript. Any other party may, at its expense, arrange to receive a certified copy of the transcript. The parties may agree, or the court may order that a deposition be taken by telephone or other remote means. And then a deposition should be of reasonable length, is limited to 4 hours, and must be completed in a single day. An unreasonable refusal to extend deposition time may result in sanctions. So 4 hours is generally the limit, but if you've reached the 4 hours and there's still some more to go, and it's reasonable to just go a little bit more, based on this rule, you should, because if you unreasonably refuse to extend it, that could result in sanctions. Now, if it's up to the 4 hours and the other side just keeps asking the same questions, this doesn't go anywhere, that likely wouldn't be an unreasonable refusal. So really that reasonable, unreasonable is a big issue here if you're going to try to deny the other side from extending a deposition. Let's look at evaluations. This is Rule 63. The court may order a party whose physical or mental condition or ability to work is in controversy to submit to a physical examination, mental or behavioral health examination, or a vocational evaluation by a physician, a psychologist, or designated expert. The way to get an evaluation ordered is by motion and notice. So an order for an evaluation can only be entered if first there's been a motion for good cause filed. Every party in the case has notice of the motion, and in particular, the person to be examined has notice. If the parties agree and submit a joint stipulation for an examination, or the court can order it on its own motion. The order for the examination must specify the time, place, manner, conditions, and scope of the examination, and must specify the person or persons who will perform the examination. So if you want to request that your co-parent be evaluated, first draft and file a motion for evaluation explaining the type of evaluation you are requesting and why there is good cause for the evaluation. You'll also need to draft and file a proposed order for evaluation, specifying the time, place, manner, conditions, and scope of the evaluation, and who will perform the evaluation. Now, when you file this order, you're not going to know the time, place, likely manner, conditions, and scope of the evaluation or who will perform it. But what you can do is fill out your order and say time of examination and write in, type in a line, place, a line, manner, a line, so that the court, when the court's ready to enter the order, can fill that stuff in once it's been determined. You'll mail a copy of your motion and proposed order to your co-parent or their attorney. Your co-parent or their attorney can file a response to the motion for evaluation, and you can file a reply to the response to motion for evaluation. The judge can grant or deny the motion for evaluation, or the judge can set oral argument on the motion and then rule on it. When the parties agree that an examination is appropriate, but do not agree on the examiner, The party seeking the examination may proceed by giving reasonable and not fewer than 30 days written notice to all other parties. The notice must identify the party or person to be examined, the place or the time, place, and scope of the examination, and identify the examiner or examiners. After being served with a proper notice under this rule, a party who objects to the examiner or examiners identified in the notice may file a motion objecting and explain their objections. For good cause, the court may order that the examination be conducted by a designated expert other than the one specified in the notice. A party must appear for the examination. If the party fails to do so, the court where the action is pending may, on motion, make such orders concerning the failure as are just. Now, at the examination, the person to be examined has the right to have a representative present during the examination and to make audio or video recording of the examination unless the court determines that it may adversely affect the examination's outcome. The person to be examined may not have a representative during a mental or behavioral health examination or make a video. If there is a copy of the examination made, then a copy of the recording must be provided to any party upon request. Once the examination's done, the examiner will make a report in writing that sets out in detail the examiner's findings, diagnoses, conclusions, and the results of any tests. The party who's examined or who produces the person examined may request the examiner's report and written or recorded notes from the examination. So this explains more about that. The party who's examined must disclose reports of all other examinations for the same condition, except for a vocational exam protected by the work product privilege. An examination conducted under this rule does not constitute a waiver of any privilege that the examined party is otherwise entitled to assert under law. All right, let's review the time to respond to a discovery request. For a subpoena, you must allow at least 14 days to respond, and then interrogatories, unless it's served with petition, you have 45 days, same with request for production, same for request for admission. And then, of course, if the interrogatory, the request for production or request for admissions, if any of those were served with the petition, then you have 60 days. Do you file anything with the court? For the subpoena, the court issues the subpoena, you file proof of service of the subpoena. Interrogatories, they are not filed with the court. Requests for production are not, and requests for admission are not filed with the court. But remember, with the subpoena, you need to provide the opposing party with a copy of the subpoena. You need to provide them a copy with the proof of service, and any documents that come out of the subpoena that are produced as a result of it, you need to provide a copy of those documents to the opposing party. Interrogatories, the questions and the answers are exchanged between the parties. Same thing with requests for production, same thing for requests for admissions. All right, we've come to the summary. First, remember the difference between disclosure and discovery. Disclosure are documents and information relevant to your case that you are required by law to share with the opposing party under Rule 49. Discovery is a variety of legal tools that are available to both parties to use. It's optional, it's not required, but you can utilize these legal tools to obtain answers, information, and documents relevant to your case. Also to have an evaluation done. So the discovery tools that we covered today are subpoenas, interrogatories, requests for production, requests for admissions, and depositions and evaluations. All right, thank you so much. Bring your questions to the live Q&A and we'll talk more there.